in the future projected to go into Medicare, taken out of Medicare, though it won't affect benefits. There are many, the provisions are numerous and complex. The strategy of the opponents, though, was to focus on the matter of interstate commerce. As I say, while many of us thought that existing precedent and doctrine supported this, a theory was developed that under the commerce power, Congress can only regulate an activity. You can distinguish cases. Every case seems to go against you. You distinguish it on its facts. So if you look at the other cases where the court has upheld the commerce power, somebody did something, like growing marijuana for medical use or operating a farm and feeding wheat to livestock. The argument was that Congress cannot regulate non-activity, such as not buying health insurance. Again, the contrary argument is that Congress can deal with the national problem. People who don't buy health insurance contribute to the national problem. They are doing something. They're becoming a self-insurer and the like. It was possible to distinguish the other cases on a constitutionally principled basis. I don't agree with that, but nonetheless it could be done. Now obviously, when the justices are deciding this, they bring into play their own views about the scope of the commerce power. Of course, the public perception is in a hot and politically charged case like this, it never gets too far from political and ideological views. Picture what would have happened politically if the court had declared the law unconstitutional and non-severable. I should make it this, I'll make it come to that in a moment. It would have been an enormous defeat for the president. He would have invested all this effort in an unconstitutional law instead of, quote, fixing the economy and the like. Also, there wouldn't be a template. There could be a debate, what would be in the law that you have. Contrary-wise, if the court upholds the constitutionality of the law, it's a political victory of some sort for the president. What he did is constitutional. The president also has a template. He can say, here's this provision, here's that provision, here's the law, and my opponents want to repeal the law. So it's no doubt that had the court gone the other way, it would have been a significant political defeat for the president. Okay, now we leave politics aside and we come to cases. When high-profile cases begin, all the media says it's going to the Supreme Court. Well, this case one would expect to go if it had turned out that all the federal courts of appeal had agreed this is constitutional, it's within the commerce power, maybe the court would not have taken it. You know, cases just don't go right to the Supreme Court. They get digested in the federal court through a district court, so there are about 87 district courts. There are 11 courts of appeal that cover some states, plus the District of Columbia. This case arose in Florida. Where a law is unconstitutional, provision of the law is unconstitutional, usually that is severable from the rest of the law. So that all that gets struck down is the part that is unconstitutional. But sometimes the part that is unconstitutional is so intertwined with the rest of the law that either the law can't stand without it, or the intent of Congress was that it couldn't stand without it. So the strategy of the opponents, there was what I call the big strategy and the little strategy. The big strategy was to have the court declare that Congress did not have the power to enact a mandate. It was focused on the mandate because people weren't doing anything by not buying health insurance. And then to argue that that's the heart of the act, and if that is struck down, then the whole act has to go with it. That's the big challenge. The second one was the Medicaid expansion. Those of you who know something about Medicaid know that it is a federal-state partnership with Congress setting the rules. The states have the choice to participate in Medicare or not participate in Medicare, and all the states participate in it. It would be unthinkable that a state would not do it. About a third of Medicaid dollars go to support seniors in nursing homes. The other dollars, of course, go to lower income people who provides them with medical insurance. As we know, uninsured people tend to use hospital emergency rooms, put off medical care, and so forth. Actually, in our medical system, if you're well off or well insured, like university employees are, you get good medical care. If you're poor and eligible for Medicaid, you get adequate medical care. If you're old, over 65, you get Medicare. It is the people up to age 64 who earn too much to be eligible for Medicaid, but who don't have insurance that are the 46 or to 50 million uninsured. And that is what Obamacare is aimed at. One of the ways to do it is to expand Medicaid. Now, usually when Congress expands it, they give the states a choice. But the deal here is so good. Congress is going to pay all of it for the first few years, and then Congress is going to pay up to 90%. Why would the states want to reject it? Some have. But Congress was very heavy-handed. It said, if you don't sign on to the Medicaid expansion, you're out of Medicaid. And that is pretty extreme. Even though many of us, myself included, assumed that Congress could put limits on spending, on grants to the state, conditional spending, this really goes pretty far. So the strategy there was to have the court declare that the Medicaid expansion violated state sovereignty, and then there were two levels of severability. One, that it struck down, that the court would strike down the whole law, or at least strike down the Medicaid expansion. Most of the focus was on whether the court would uphold the law. But really, the court could have gone another route. Striking the law down is beyond the Commerce power, but saying it's severable. The federal district judge in Florida said that this is beyond the Commerce power, the law is not severable, everything goes. The U.S. Court of Appeals for the 11th Circuit in the 2-1 decision said the law is beyond Congress's power under the Commerce Clause, but the rest of it is severable, which meant that the rest of the law survived. If the court had done that, that would have also been a victory for the Obama administration. So, what were the possibilities? I never predict how a case is going to go because it's all speculation anyhow. I promised to do an op-ed for the Free Press, and I did 4 what I call shell op-eds. And I'm just going to fill in the blanks after the decision. One op-ed, the court upholds the individual mandate. Second op-ed, the court strikes the individual mandate down as beyond Congress's power, but says the rest of the act is severable. First 2 are victories for the Obama administration. Third, the Obama administration, perhaps for politics reasons, made the argument that if you strike it down, you have to strike down the individual mandate and community ratings of individual policies. If the court did that, it's a victory for the Obama administration. It's the fourth possibility that would have been the defeat, that the mandate is unconstitutional and the whole act falls. I didn't pay much attention in my Shell op-ed to the Medicaid expansion, because that was a fairly minor, I saw that as a minor issue. The court decides, and we can speculate and speculate why Chief Justice Roberts did this. None of that matters. All that matters is, as I tell my students, you have to count to 5. You get 5 votes, and that is a holding of the court. 5 justices, Chief Justice Roberts, and Justices Kennedy, Scalia, Alito, and Thomas, in a joint dissent, said that it is beyond the power of Congress under the Commerce Clause to regulate non-activity. That you can only regulate activity. Congress does not have the power under the Commerce Clause to require individuals to purchase insurance. Well, that means when I teach the Affirmative Commerce Clause and the plenary power, I have to say except. But who cares? Chief Justice Roberts then said, however, even though this is called a penalty, it can be sustained under the taxing power because it is like a tax. The taxing power is a very powerful power. We don't think of it that much. We just take it for granted. For example, Social Security is politically marketed as a form of government social insurance. You pay into it and you take it out, even though it doesn't follow insurance principles, it's bottom weighted and the like. However, that's not the constitutional basis. It's a tax. You pay FICA every payday, and you get benefits. In theory, Congress could reduce or cut the benefits. It's a tax. So Chief Justice Roberts says that this penalty, which is really like a tax, it's collected by IRS, and even though Congress didn't call it a tax, we can uphold it under the taxing power. 4 liberal justices, Ginsburg, Breyer, Kagan, and Sotomayor, gladly joined that, even though they didn't agree with it. They wanted to base it on the Commerce power. So you have 5 votes now for upholding the mandate, therefore we don't get into severability. When it came to the Medicaid expansion, 2 other justices, Breyer and Kagan, I believe, said that this goes too far and that the states have to be given a choice. But that's severable. So the bottom line is that the law is upheld. As for the Medicaid expansion, the states have a choice. Governor Perry of Texas, Governor Scott of Florida said, we're not going to do it, we're not going to do it, we're not going to do it. Though it's a bad deal for the states who don't, because their residents get taxed to pay for other states doing it. Maybe by the time 2014 comes, they will take a somewhat different attitude. Now, the political effect of the decision, as I call it. As I said, if the court had struck down the mandate and struck down the whole act, would have been a tremendous defeat for the Obama administration. Governor Romney and the Republicans would be campaigning about a failed presidency. Instead of trying to help the economy, Obama puts all this thing on an unconstitutional law. Obamacare is unconstitutional. And then in the election, the campaign, Obama and Romney would debate over what would be the contents of a new health law, with Romney getting all the advantage because what Obama proposed was unconstitutional. Did the decision affect attitudes toward health care law? Well, as time has gone on, attitudes have been improving somewhat as people see some of the provisions kicking in, like insurance companies can't cut you off anymore. You can keep your adult children until age 26. And those of you who have adult children at that age would often like to keep them on the policy. And there is some legitimatizing effect of a Supreme Court decision. So I think the polls, again, the center librarian collected all these polls for me. There's one that showed nationally split. 46 agree with the decision, 46 disagree. Democrats go 79 to 16 agree, Republicans 13 to 83 disagree. And the polls are very similar. What is interesting is that the Supreme Court has been losing ground in public approval. I think the polarization that we have seen politically has carried over to the court. Liberals were very unhappy with the Citizens United decision, although some of us who are free speech advocates were strongly in favor of it. Conservatives are unhappy now about the Affordable Care Act decision. What is interesting is that the surveys show something like 70% of the respondents believe that the justices base their decision on personal and ideological views rather than, quote, the law. Now, I think there's a problem with that kind of survey research because you can't separate views on the law from ideology. As I would say, I certainly expected Justices Scalia, after this case got up to the court, I certainly expected Justices Scalia and Alito and Thomas, who want to limit federal power, to find the Affordable Care Act unconstitutional. I thought Kennedy and Roberts were more in the middle, and that came out on the oral argument, which I read the transcript and watched it carefully. I thought that they could go either way. In the end, they both agreed that Congress did not have the power under the Commerce Clause to do it, and Roberts' invocation of the tax power was a surprise. The Obama administration waffled on that. It was not much of the argument. Meantime, and I know you all have some questions and comments, and I could talk forever, and some would say that I do, but I want to get off it and turn it up to you with just one political observation. During the Republican primary, Governor Romney strongly attacked Obamacare, promising to repeal it from day one when he became president. You don't hear much of it in the Romney campaign. Why not? Juan Williams, who's a columnist for Fox News, called this the dog that didn't bark. You don't see campaign ads from Romney attacking Obamacare. You don't see much of an attack on Obamacare. When it came up during the debate, he just said, well, it ought to go state by state. Now, the interesting question, watch for it tomorrow night, will the president do this? I mean, I assume that tomorrow night the president's going to say, I am proud of my record. Is he going to do, as Chris Matthews suggested on CNBC, say we're now going to insure 50 million Americans and so forth? Jeffrey Anderson, a columnist in the Weekly Standard, said, what are you doing, Republicans? Very conservative. What are you doing, Republicans? You won the 2010 election in part, mostly because you attacked Obamacare and big government. Well, why aren't you doing it now? And I think one of the main reasons there was doubt until the Supreme Court was going to decide. But once the Supreme Court decided, there is a certain sense of legitimacy. There is still a sense of goodwill toward the court. I was going to make a few historical observations. Prior to the Plessy versus Ferguson situation in 1896, Jim Crow laws were not widespread in the South. And once the Supreme Court said that they were constitutional, there could no longer be an objection to them in the South. The Brown decision is considered in many ways a major factor in the civil rights movement, the success of the civil rights movement, political success, leading to the Civil Rights Act in 1964. When I was at the University of Kentucky, circa 1970, I litigated the Kentucky version of Roe v. Wade for the Kentucky ACLU. Not very successfully, but the Supreme Court decided the case. And there was widespread opposition to abortion. Now, there still is, but it's much more even now. In a sense, once the Supreme Court said that a woman had a constitutional right to a safe and legal abortion, it legitimatized abortion in the eyes of many in a way that was not so when abortion was illegal everywhere and women and the Supreme Court, and it did not appear to be unconstitutional. There's some of this happened with the Affordable Care Act. Well, I've talked a lot, and I know you all have questions and comments, so why don't we switch from me to you with your questions and comments? Yes?
I have one theoretical question and one practical one, if I can keep them straight. The theoretical question is, why not argue that what was attempted in the original act, the Obamacare Act, was not the regulation of non-activity, that everybody requires health services, and that activity is universal, and all that the government was doing was regulating the way in which those health care services would be provided.
That argument was made in all the briefs. It was made in oral argument. It was made by the 4 justices in the Ginsburg opinion that disagreed with the holding. My point, I mean, to me, as a constitutional analyst, that is the most logical argument. But as I said, you had, I think, certainly 3 justices that are opposed to federal power, period. And then I think you had Kennedy and Roberts that, in the end, did not buy that. And they came at it different ways. I mean, Kennedy said this is just, joined opinion, dissent, that said you can't do this and the whole thing falls. Roberts, I think, again, this is speculation, and I don't speculate except among friends. I think Roberts was very concerned with the role of the court as an institution and the downdraft that would have followed if the court struck it down. And yet he wanted to make a point about the power of Congress over interstate commerce. So I think that's why those arguments were made. The court, they've got 4 justices, you need 5.
Now the practical question. I believe the minority argued that what was being imposed was a penalty, not a tax.
Correct.
And that you could not have something that was both a penalty and a tax.
That is correct, absolutely correct.
And then further argued that the statements in passage of the act and in defense of the act all referred to it as a penalty.
Absolutely.
How did the majority overcome that?
This is Roberts. It's only Roberts who is writing this. Remember, he is the decisive 5th vote. And Roberts says, doesn't matter what you call it. It's not, this so-called penalty is not enforced criminally. It's enforced by IRS as part of your tax deal. It is more like a tax. Now, the majority says, interestingly enough, Congress could have made this a tax, but it didn't. And they put a lot of weight on what was said. Now, this is interesting, too. Again, I'm trying to recreate what may have happened between the lawyers and the political people. I mean, we do this all the time. My son in Chicago has a public relations firm, and public relations people are concerned about public image. So, you know, what do you do with damage control? Well, lawyers say, don't say anything, don't say anything. And the public relations people say, you're going to hurt yourself if you don't say things. And I can picture this happening here, where the lawyer's saying, look, we can't be sure that it's going to be upheld under the commerce power. Let's go with backing up with the taxing power. We'll call this a tax. The political people say, no, we can't call it a tax. And this is where the dissenters said, Congress didn't call it a tax, called it a penalty. It's a penalty and not a tax. And Roberts, who, if I'm right, wanted to uphold the law, said the language didn't matter. Now, you now have 5 votes that says the language doesn't matter. That's the holding. Remember, it doesn't matter why the individual justices voted the way they did. All it matters, I don't spend a lot of time in my teaching going over dissents. Now, a lot of my colleagues do, because they believe there are better decisions and not so good decisions, but to lawyers, it doesn't matter. And so what matters only is that the law has been upheld.
Well,
yes?
Mine kind of goes actually with his, and this taxing power. If it's non-activity, Congress can't regulate it, which is good. So if I were to pay the penalty, if I don't want
insurance,
you compared it with the Social Security, FICA, being a tax, but the difference maybe why they can't call it a tax, because if you were to tax me, I would get something in return.
Well,
if they call it a penalty, I'm paying that tax,
right,
but I'm not getting anything in return
the
for
way,
my penalty or my tax per year.
The way
right?
that Roberts hand that, and I don't have the exact, should have brought the case with me. He put it in terms of, well, you're paying a tax because you chose not to have insurance. In other words, the government can say, we want you to do something, and if you don't do it, we're going to put a tax on you to help support the rest of the program. You see,
but I'm going to pay for the people that are in the program, but I'm paying myself out.
Well, you know, it's like we have to
I guess that's where I'm having the issue of.
Well, let me draw on a comparison to school taxes. You have to pay school taxes, even though you don't have children in school. And of course, but that's a clear tax. And the idea is there's a public benefit educating children. So here, there's a public benefit in insuring people. And if you don't want to be one of them, then you've got to pay a tax. It's the same reasoning that puts the tax on employers of more than 50 who don't provide health insurance. Again, theorists, this is my point, that theorists can debate this. Nonetheless, the case stands as a precedent for the taxing power. That said, a good lawyer would say, politically or not, if you want to sustain under the taxing power, you should call it a tax.
But, not to interrupt, but a tax is applied to everybody. And did the minority argue that this cannot be considered a tax because it only applies to a specific class of people?
Well, you know, you can tax a class of people. Taxes do not have to be uniform.
Okay.
There was an argument, you know, that, under Article 1, along with the census, a head tax has to be a tax of everybody. But look at all the people that don't pay income tax, and that is true. Municipal employees weren't compelled to pay FICA. So I think that then there's a broader thing that comes out in the Roberts opinion. And it's like whenever the court wants to uphold the power of Congress, it emphasizes we're going to defer to Congress, we're going to allow Congress to exercise judgment. When the court wants to strike it down, it says Congress has gone beyond allowable judgment. But Roberts talked a lot about deferring to Congress in this case. One of the ironies is that to the extent that the opinion may have, decision may have hurt the court's public opinion, which is questionable, but it's an irony that it did so while the court is deferring to Congress. But again, see, I think that what has happened is that we have become so polarized politically that this has gone on to the court itself. And this goes back to the Bork nomination in 1987, when Scalia was nominated in 1986. His views were known. He was an academic before, he was a staunch conservative, and he was confirmed without any controversy, because at that time, the only objections to a Supreme Court nominee, or for that matter to any federal judge, had been character types. The Democrats and the liberals started this with Bork. Because they saw Reagan, unlike his predecessors, with the advice of William French Smith, his Attorney General, and others, Smith wanted to try to get conservatives on the courts. And so the Democrats struck back. By the way, Clarence Thomas was, gone on the court in 1991. That we owe to Joe Biden. Biden was the chair of the Senate Judiciary Committee. And all the Democrats got spooked by race. I mean, my comment on Thomas at the time was, he's a black Bork. Now, that was a media comment. It was basically saying he is an ideological conservative like Bork, and that he didn't have the stature at that time to be on the court. It was a purely political appointment. But so many Democrats had come out for him that they couldn't backtrack, and he backtracked when the Anita Hill thing broke. So it was 52-48. What they should have done from the beginning was to say he doesn't have the stature and experience to go on the court. They were afraid to do that. Anyhow, things have become very polarized. You can see, I mean, the polls are accurate. Everything is very, very close. People are strongly divided, and this shows up in attitudes toward the court. Yes?
Is the political polarization largely devoted to just not only medical, but so many controversial decisions that we've had over the years that have raised a lot of public ire, that, like with the Chad thing, with the elections, did that have did that sort of make another further wedge into the court?
Well, interestingly enough, it didn't. There was a public acceptance of the decision, even though after a few weeks all it died down, even though many people disagreed with it. There was I'm just looking at a statistic. It said the public percentage of respondents who agreed with Bush v. Gore was 50%. But even among the disappointed Democrats, there was a recognition of the role of the Supreme Court to decide this. When I give my speeches on the Supreme Court, I point out that by far they decide maybe about 70 cases a year. The largest number are decided unanimously or 8-1. It's the high-profile, ideologically charged cases that get public attention, and we would expect those to be cases where the justices are divided based on their ideological views. Although sometimes particular justices have different views. For example, Justice Scalia, who is so-called classic conservative, has a view about the Sixth Amendment, guaranteeing the right to jury trial, guaranteeing the right of confrontation. And in those cases, he will often come down on the side of the person accused of crime. Whereas when it comes to the Fourth Amendment's guarantee against illegal searches and seizures, then Scalia is not very favorable to defendants. So, you know, you can never categorize things so easily. Justice Kennedy's in the case that I'm working on now with a former student of mine involving same-sex marriage in Michigan. Justice Kennedy, there are two decisions involving the rights of same-sex persons, one of which was a state constitutional amendment prohibiting the inclusion of sexual orientation in anti-discrimination laws. It was decided on equal protection grounds, and Justice Kennedy wrote the opinion, was very, very strong how unconstitutional it is to exclude a class of people from the protection of laws. The other case, 2003 case, involved a Texas law prohibiting oral and anal sex among same-sex persons, and Justice Kennedy is very strong in that opinion about how those kind of laws demean individuals, and so he comes out very strongly on that. So it's they don't lend themselves to the neat predictions that the media will give you, Mark.
I had a follow-up on Bush v. Gore, since we're dealing with, again, you know, it's not a specialty area, so, by the way, so I'm still smarting about the 2000 election.
Okay.
Just thinking this morning that if there's one villain in America, it's Ralph Nader. But there's a libertarian that the Republicans are trying to squash, former governor of Mexico. I remember my memory, and you know, I didn't really study this in great depth, was that Scalia actually published or said something that there was a crisis and the court had to act. And it seemed to me that I scanned the, I think it's Article 2 of the Constitution on elections, and it seemed to me that there actually was a, it's probably Article 1, that Congress has the power to determine evenly balanced elections. I mean, couldn't the election gone into the Congress just as it did in
Well, remember
1800 or 1796?
See, I'll bet that did you ever say that Gore won the popular vote?
Sure.
That's misleading. Let me tell you why. But your point about going into the Congress just proves that. We don't elect the president.
We elect electors.
It's not like France, where everybody votes, and whoever, if nobody gets 50%, they have a runoff. What we call the popular vote is the sum total of votes for electors. Look at the campaign. Why are they in Ohio all the time and not in New York or Texas? If we had direct election of the president, there wouldn't be battleground states. They would be campaigning in New York and California and Texas. How many Republicans don't bother to vote in New York? How many Democrats don't bother to vote in Texas? So the popular vote is misleading. There were many ways that the court could have reached a decision that it did. To me, the most obvious one, because I agree that Florida's recounts did violate the principle of equality of vote, is simply send it back to Florida and decide this under appropriate standards. There was no urgency to say, well, Florida law requires that the electors be certified on such a date. So there are many ways to criticize the decision in Bush v. Gore. My point is that there was acceptance of the role of the court in resolving that election, even though there was, strong disagreement with how the court came out.
But the acceptance relative to a poll on something as important as this substantially depends on the leadership of the parties. And in this decision,
What are we talking about? Bush v. Gore?
Gore v.
Yeah.
Bush v.
Yes.
Gore.
That after this decision, the Gore camp did not take a fight on the principle that the court had decided, and in fact, if I remember the video clip, denied access of black representatives to lodging a complaint on the floor of the Congress in the name that the court had done this, it's over. So yes, the public has this opinion, but are the public, are they leading, or are they really following people who say, we're not fighting it, why should you fight it?
Again, I think that there is a public acceptance of the role of the court in deciding constitutional questions, even when there's strong disagreement with the decision. And again, I think that the Affordable Care Act is illustrative. I think that if the court had said that the act is unconstitutional, the Romney campaign would be attacking Obama on Obamacare all the time. It's not.
Can I press you a little further on Bush v. Gore? I guess Congress can only decide if the electoral votes are equal.
No, the votes go to Congress. That they go to the
that's right, in Congress.
and they have a joint session and they open them up.
Right, but was the so-called crisis that Scalia foresaw that no president would be selected by January 20th if the Florida counting of the its electoral vote were contested?
Right, and again, my
so we'd have no government.
That the court, well, again, the court could, the decision was on December 12th. The court could have sent it back to Florida on a quick timetable. No, I think the court as an institution, led by the Republicans, at least by 5 Republican justices, said, let's bring it to an end. Now again, they're going to debate forever.
Okay.
Was this to help because Bush was the president? My view is that part of the public opinion was, if that was so, so be it. I don't think there was I don't think there was a lot of public support to continue the controversy. Also, we were not as polarized in 2000 as we were. Remember, Bush ran on compassionate conservatism. We didn't have any war in Iraq. I think that Ralph Nader was successful in getting his 3% of the vote because to a certain segment of the public, there wasn't any difference between Bush and Gore. You would not have that today, where there's the polarization. Yes?
You say, you keep telling us, and you're right, that there wasn't enough opposition, public opposition to Gore v. Wade.
Bush v. Gore.
Yes, and I think it's because me and a lot of people just assume, oh, the Supreme Court has the final say.
Correct.
We can't do anything about it.
That's correct.
And if that's correct,
It is.
Isn't there a problem with our whole, that basically the Supreme Court can do anything they want,
No.
depending on who's appointed,
Well, see, this again,
based on their interpretations?
in theory, the court is supposed to be above politics, is supposed to apply constitutional principles, which is why they have life tenure. And I think the system works pretty well. And part of it is that there is an acceptance of the role of the Supreme Court, as I put it, in defining the meaning of the Constitution. I'll just tell you a story, and I guess it's time to always end on a story. The night that Bush v. Gore was decided, I was at a party with my wife, very prominent lawyer who put on very, very good parties. When I'm with my wife, I can drink freely because she's the designated driver. And I had a very good time. I came home, and there was a phone call waiting for me from a reporter of WJR. I had not heard the decision. And she said, did you know of the decision? And I said, no. And she told me what it was. There were two other prominent liberal lawyers commenting, and they were bashing the Supreme Court. I pointed out that the institution that you're bashing, the Supreme Court, is also the court that gave us Roe v. Wade. And you probably are very supportive, my fellow colleagues, of the decision in Roe v. Wade. The fact is, whether it's liberals or now conservatives, when you lose in the legislature, you take your case to the court. You try to make a constitutional argument. This was done by businesses in the 19th and early 20th century to attack social and economic regulation. This was done in the New Deal. After the New Deal, it was the liberals who were doing this to protect personal rights, such as a woman's freedom of choice. So, I mean, all of us at times want the Supreme Court. So maybe the best answer to your question is the equivalent of mutual assured destruction. We all need the Supreme Court to challenge laws and actions that we don't like. And the downside of it is, so will the other side.
Right.
Thank you, Walter. I think we've done it for today.